An action by the U.S. Supreme Court earlier this week made it easier for the Trump administration to apply a wealth test to prospective immigrants. In a 5-4 ruling, the conservative majority nullified a move by the federal appeals court that blocked recently instituted immigration restrictions. The ruling effectively allows U.S. immigration to deny admission or residency to immigrants on public assistance or those deemed likely to become a public charge. According to a leading immigration think tank in D.C., the Migration Policy Institute, majority of future denials are likely to be from Latin America and African countries. The Wall Street Journal, however, cited that the action by the Supreme Court is not final on the merits of the case. A press release from the U.S. Citizenship and Immigration Services states that the implementation of inadmissibility on public charge grounds will begin to be implemented on the 24th of February. Among the determining factors to be considered for inadmissibility include an alien's age, health, income, education and skills, amongst others. So we're going to get started right away, and I want to throw this out to the panel and also to the listeners. And I think it's important for us to describe, who's not covered under this. For those who tuned in to the show last year when Ms. Fatmata Barry here was here, at that time, the White House had just announced this, and they were going to start implementing it on the 15th of October. That was last year.
Right.
But because of a number of court cases and litigation that was going through, there was an injunction that was put through by a federal court of appeal, blocking the White House from implementing that rule.
Yes.
However, White House went to the Supreme Court, and the Supreme Court said that
Kazi
endele. So they said while litigation is going on, the White House can proceed. So effectively, this case is not over because it's still in lower courts. But I think Supreme Court has already indicated that by the time it makes it to the Supreme Court, they've already indicated how they're going to vote, the 5-4 vote. Right now, the swing vote in the Supreme Court is the Chief Justice, Roberts. Yeah, but indications show that he will vote with a conservative majority. So that's where we are right now. So the White House is set
but
to start implementing these rules.
4 people who didn't vote? Or
No. The ruling was 5-4.
Which is 9 people, right?
Yeah. The ruling was 5-4.
How many?
So 5-4, there are 9 people in the court.
In the Supreme Court?
Yeah.
Nine Supreme Court.
So the 4 were the dissenting.
Yeah, okay. so the 4 liberals
but he didn't vote. So how was it 5-4?
What do you mean he didn't vote?
Because he was in Nini.
It was 5-4.
He was at impeachment. He was impeaching in
this wasn't the vote. He put in his vote. This wasn't the vote. This wasn't a vote like as in a ruling. I don't even want to call it a ruling.
It's not because it's not. There's nothing that's signed.
Because this was just something the Supreme Court saying. It was kind of like what we call an advisory. The Supreme Court was saying the federal court cannot stop White House from implementing this before they reach a ruling. So the federal courts have not reached a ruling. Yeah, but they just blocked the White House from implementing these policies while litigation was going on.
Which makes sense.
So, but now the Supreme Court came out and said that, yes, you actually cannot do that. So now the White House
the way they've interpreted it, they're saying you can't do that.
No, the Supreme Court is not about the way they interpret it. It's a final rule.
No. But it's the interpretation, right? So you see, the thing about the law, the way the law is written a certain way, then they have to interpret it. So they are the final people who do the interpretation. So if they say that this is the way that it's supposed to go, then that's how it's going to go.
That's how it's going to go. But remember, this is not a law. This is executive action.
Exactly.
Yeah.
Exactly. Which, anyway, it's all good.
Yeah.
We are at least it's being challenged, but then people need to be real.
Yeah.
And this has been coming since last year. So.
Yeah. So pretty much, I think it's important also for people to understand that this does not affect current green card holders or green card holders who are currently in the application process.
If you apply before February 20th.
Yeah, even for those people who will apply before
you have to apply
February 24th, yes. This will not affect you. Mika?
Does it come in play from August? Any other applications that will come from August? If you read what the USCIS put out today, any application that's coming from August 2020, they're going to be affected with it.
No.
If you're changing your status from one to another.
No, Mika, that's not what it is.
What did the UC? Because there was a press release.
What there was. Okay,
So,
so because remember it was.
Statement from
And Mika, your sound. There's something wrong with your sound. We can't quite hear you clearly. I don't know whether listeners can hear you clearly. There's something about with your sound. We're gonna try to take care of it. Omosh, you're saying something.
So my understanding of it was that because the original thing was from October, so if you were somebody who applied, but then you got benefits in between like around October hapo, then now they would put you under that nini, because it's almost like since they wanted to start enforcing it from October. So if you're someone who is applying and you've never gone for benefits, then ukopoa. But if you have taken benefits and your benefits were taken after October, but you applied, then sasa hapo ndio pale kuna kasheshe. Now, that was my interpretation of it, unless Mika interpreted it a different way.
Mika?
Almost you're mixing up these things. The February 22nd is the
24th.
travel manifest.
Huh?
Is the one for the Six Nations. The 22nd, the one that is taking effect on February 22nd, is the one that is for the 6 countries that have been extended on the ban. But for this one, the charge, yes.
No,
but for
Mika.
the charge rule implementation.
No, Mika. Let me actually read.
Go read the.
Okay, give me a chance. Okay, give me a chance. Let me read. This is from the uscis.gov website. And it's titled USCIS announces, and this is dated January the 30th, which is yesterday. USCIS announces public charge rule implementation following Supreme Court stay of nationwide injunctions. And it says the U.S. Citizenship and Immigration Services will implement the inadmissibility on public charge grounds final rule on February the 24th, 2020. So this is on the USCIS website. So this is not disputable, except for the state of Illinois. And of course, this was explained why Illinois
because
is
they
going
have
to be an exception.
They have ongoing litigation.
So it's not August. It's actually February the 24th. It was meant to start on October the 15th of last year, but because of a court injunction, they were not able to start implementing it. So this was put on hold until the Supreme Court, of course, took this action of telling the federal courts that you cannot stop this while the litigation is going on. So what's most likely to happen is that the federal courts will still, rule against it. So once the federal courts rule against it, that's when it can officially stop. So the Supreme Court cannot negate a ruling of the federal courts unless the ruling comes to someone appeals and brings it to the Supreme Court. So at that point, most likely the White House will appeal, bring it to the Supreme Court, and the Supreme Court will overturn the ruling of the federal courts.
Or not.
Yeah. So
with the way the court is
stacked.
Yeah.
Yes.
With the way the court is stacked, chances are, there's maybe a small chance.
Decides, you know what? Nyi watu mnafanya unini.
Yeah, but I don't think that's going to happen. Almost you're saying something.
So, further on for what DHS, or should I say USCIS have said is the final rule prohibits DHS from considering an alien's application for certification or approval to receive or receipt of certain non-cash public benefits before October 15, 2019, when deciding whether the alien is likely at any time to become a public charge. In light of the duration of the recently lifted nationwide injunctions and to promote clarity and fairness to the public, DHS will now treat this prohibition as applying to such public benefits received before February 24th, 2020.
Okay.
So, kuna vile.
So explain that in simple words.
The way I understand it is that if you get your public benefits before February 24th and you apply, then they will look at that and say that sasa now wewe ume receive. So they can use that.
So they'll start looking at receipt of benefits from October 15th.
From October 15th.
That makes sense.
Okay.
So that's they were cutting it in that window. However, what they're saying is that if you didn't receive and you apply, then that does not nini. So now it's up to the officer who can then now decide and say, okay, are you likely So they can look at you and say, wewe, you don't meet the threshold of the 125% income. So you're probably more than likely to ask for benefits at some time or the other.
Yeah.
And so the issue then becomes that people who have kids, who are aliens and the kids are US, if they are suffering, they don't want to go and ask for benefits.
Yes.
So they are opening this up to go down a very bad path.
Okay, Mika.
What benefits are we looking at? What are we seeing that they're... So
public
let's say
benefits,
you are hired,
Medicaid and stuff.
Is that is unemployment in that list?
I don't know. I don't know if unemployment... unemployment is not a federal benefit.
Also weak in that list.
It should be a federal benefit. It should be a federal benefit. And Medicaid is a federal benefit. And unemployment is not a federal benefit.
And Fatmata Bai, when she was here on the show, she described the different types of benefits that are being targeted, and I think that's a show that we're gonna revisit, and we're gonna post it back, so that our listeners and our viewers can benefit.
I think we really need to bring her in here, and my suggestion is we bring her in here after February 24th. The reason why I say that is that also the USCIS are also going to have sensitivity / training or whatever, where they're actually going to sit down with lawyers and everything and have sessions where they are familiarizing them with what it is that this new law or whatever it is that they're trying to enforce is.
Yeah.
Because there are people who understand it on paper, but it's not been explained. Because, when you sit down and you have a question and answer session and you have scenarios and they're letting you know, okay, if you have clients who have applied under guise X, Y, Z, or they've done this, or they've applied for this, or they have taken this, or they have done this, then they fall in this class. And we would consider them on a case-by-case basis, blah, 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 which they normally do. They always consider you on a case-by-case basis anyway. Yeah. But now they're really pushing towards this thing where basically at the end of the day, the people who are going to suffer is Latin American immigrants and Africans, which leaves Europe wide open, and the people who are their skin color is not like ours.